So welcome everyone to our collaborative outreach with the Financial Sanctions Implementation Unit. And thanks again for your patience. We had some major technical issues with using WebEx webinar. And so we sent this revised invite this morning. So hopefully everyone has received it. I know a few more people were joining. We're up to 101 attendees. So this is a collaborative outreach with FSIU involving the real estate and dealers and high value goods sectors. My name is Gledwina Umara, and I'm the Assistant Superintendent of Real Estate. And I have on the call some of my team, Mr. Egbert Simons, our Senior Compliance Officer, and we have our Administrator, Ms. Crystal Fox. Let's just see if we can mute a few people. I hear a lot of background. And we also have the Financial Sanctions Implementation Unit. We have the Director, Ms. Renee Fogo, and we have the lawyer, Ms. Jaleesa Simons. So I'm just going to go briefly through this morning's agenda. So we're going to cover the overall targeted financial sanctions as it impacts the real estate sector and dealers in high value goods. We want to make it whereby it's applicable to you. So hopefully you're able to take a few takeaways and apply it within your operations. We're also going to go through reporting for targeted financial sanctions, proliferation of financing indicators, the effect of Russia on Bermuda's sanctions regime, and then we'll conclude with the 2023-24 relicensing reminders. And for that portion, I know we have a few dealers in high value goods represented here today, so you're more than welcome to drop off the call once we reach the relicensing reminders. And now I'm going to hand it over to FSIU, and they will get underway with today's presentation.
My name is Renee Fogo, as Gladwina has already intimated, and I head up the Financial Sanctions Implementation Unit. So we are going to just go over our presentation with you this morning. And please, if you have any questions, you can put them in the chat feature, I believe. And what we will do is look at the questions at the end. We'll have a Q&A section or session at the end of the presentation where we will, it'll be just easier to do it that way. Okay, and I have assisting me today my legal with the FSIU, Jaleesa Simons. So we can go ahead. Next slide, please, Jaleesa. So what is the Financial Sanctions Implementation Unit and what do we do? If I could sum up our key areas that we do, it would be licensing with respect to sanctions matters, compliance and outreach. So basically we are a unit within the Ministry of Legal Affairs and Constitutional Reform headquarters. And we were established to provide support to the minister in carrying out certain functions that have been delegated to her from the governor. And we have been operational since July 2018. And we are a small unit, and basically it's myself and Jaleesa, but we do also receive assistance or administrative support from the ministry headquarters. And as I said, our primary roles include considering license applications, assessing suspected breaches, and ensuring robust enforcement for sanctions, Bermuda's sanctions regime, also raising awareness of financial sanctions obligations through outreach and other methods, notifying supervisors of sanctions updates of the various sanctions regimes, and the supervisors then pass on those notifications to their supervised entities. In your instance, it will be the superintendent of real estate. We also work closely with law enforcement agencies and operational partners. And we also engage quite heavily with our relevant UK counterparts and also our overseas territories and crown dependency counterparts as well. Next slide. So in Bermuda, let me talk about who is subject to targeted financial sanctions. Basically everyone in Bermuda. And these sanctions are from the United Nations and also the UK. So all individuals and legal entities who are within or undertake activities in Bermuda are subject to Bermuda sanctions regime. The UK's OT orders that are enforced in Bermuda provide for financial sanctions to apply widely, including to any person in Bermuda and any person on board a Bermuda registered ship or aircraft. And FSIU guidance is available on the sanctions measures webpage of a government portal. And when we look at our sanctions regime, it's a combination of UN sanctions that come into force via the UK's autonomous regime, and also UK imposed sanctions, so UK domestic sanctions. There's persons that are basically sanctioned under the UK's domestic regime, are also designated persons under Bermuda's regime. Next slide, please. So what are your obligations? Basically, you must have adequate resources in place to be able to comply with Bermuda's sanctions regime. So if you know or have reasonable cause to suspect that you are in possession or control or otherwise dealing with the funds or economic resources of a designated person, you must immediately freeze the funds and or economic resources of that person. And you must not enter into any financial transactions or provide financial assistance or services in relation to the designated person or any third party. And proliferation, nuclear or other sanctioned activities, unless there is an exemption in legislation upon which you can rely on, or unless you have obtained a license from the FSIU. You must immediately report this to the FSIU. And you also need to complete the compliance reporting form as soon as possible. Next slide. So the consolidated list, we wanted to mention this again. You may have heard of it in previous outreach, but basically it is your responsibility to ensure that you are receiving notifications on a timely basis of changes to the consolidated list. Now the FSIU does send out information to the supervisors. There is a way for you to also directly sign up for notifications from the UK. And this is the link right here. We can have the superintendent of real estate share that with you if you're interested. But these updates basically amend the list. And this is the list upon which you should be screening as part of your due diligence, particularly when you have new clients or what have you. And it is for you or your organization to determine, obviously taking a risk-based approach, how and when the screening checks will be done and what your process will be in generating the report sent to the FSIU. So we mentioned the compliance reporting form, which is referred to as the CRF. So you would submit that via email to the FSIU, and it should include the UN and or the UK group ID number, any information that you held about the individual or designated person by which they can be identified, and also information or other matters on which the knowledge or suspicion is based. So why you suspect that they are a designated person or what have you. Your report should also state the nature and amount or quantity of any funds or economic resources held by you for the customer. The CRF, as stated, is located on the FSIU webpage, which is on gov.bm/international-sanctions-measures. And if you are unsure about any of your reporting obligations, you should seek independent legal advice. And it's also important to note that any information that you provide to the FSIU will only be used for the purposes for which it is received. Okay. So when we talk about resources, and we say you should have adequate resources, basically you must have resources to implement the policies and procedures in order to comply with Bermuda sanctions regime. Your resources should provide for these policies and procedures to comply with your obligations, which should be properly documented, reviewed, and endorsed by senior management. You should also determine your risk profile. Also, relevant staff should all be trained and assessed on how to comply with your financial sanctions compliance procedures. And again, such procedures should be recorded, audited, and updated on a consistent basis. Your processes should include adequate mechanisms at the start of a new business relationship and on an ongoing basis in order to prevent designated persons from entering into prohibited activities. So for instance, like where you have a new customer or client, you should be checking their name against the consolidated list. And I would imagine that you will already have KYC or CDD policies and procedures in place. So checking the consolidated list for sanctioned individuals should also be a part of these processes and procedures. And there may be some other things that we'll come to later that may, or present red flags or what have you that may wish, there are circumstances you may wish to do, more enhanced due diligence. Next slide. Okay, so we'll now move on to ownership and control. When a person is designated, their name is recorded on the consolidated list. However, an asset freeze and some financial services restrictions will also apply to entities that are owned or controlled directly or indirectly by a designated person. Therefore, like the entities may not be designated themselves and not necessarily placed on the consolidated list. However, such entities that are owned or controlled by designated persons are also subject to financial sanctions. So, well, how do we define ownership and control? So basically, a legal person or entity is owned by another legal person or entity where there is possession of more than 50% of the proprietary rights of an entity or having a majority interest in it. If this is met and the owner is also a designated person, then financial sanctions will also apply to the entity that is owned by the designated person, or DP. And owned is interpreted to include direct and indirect ownership. Whether a DP is in control of another legal person or entity must also be considered. So financial sanctions apply where a DP may only possess a minority interest, A person or entity is deemed to be controlled where the DP holds directly or indirectly, like we said, more than 50% of the shares of voting rights, or has the right directly or indirectly to appoint or remove a majority of the board of directors of the entity, or it is reasonable to expect that the DP will be able to ensure the affairs of the entity or person are conducted in accordance with the DP's wishes. And it's important to also note that the provisions governing ownership and control apply equally to persons or entities designated for terrorist financing and for proliferation financing. So we just wanted to touch also briefly on proliferation financing, which is the act of providing funds or financial services which are used in whole or in part for the manufacture, acquisition, possession, development, export, transshipment, brokering, transport, transfer, stockpiling, or use of nuclear, chemical, or biological weapons, and their means of delivery and related materials, including both technologies and dual-use goods for non-legitimate purposes. in contravention of national laws or, where applicable, international obligations. And that's the Financial Action Task Force definition of proliferation financing. So when it comes to proliferation financing, you may wish to assess the following areas of your business to consider whether PF is adequately addressed: the provision of staff training, implementation of policies and procedures, risk assessments of customers and products, and application of enhanced due diligence in respect of higher risk transactions and entities. Next. Okay, so we also wanted to highlight potential red flag indicators when looking at proliferation financing. And we have put them under 3 categories. So when it comes to customers, red flag indicators would include individuals or entities targeted by sanctions or connected to a targeted person. A customer is involved in the supply, sale, delivery, or purchase of dual-use, proliferation-sensitive, or military goods, particularly to higher-risk jurisdictions. Or a customer is vague, particularly about end user and end use, provides incomplete information, or is resistant to providing additional information when that additional information is sought out. These next 2 categories, transactions and jurisdictions, may be more applicable to this sector. So when we look at transactional-based red flag indicators, so where a transaction involves financial institutions with known deficiencies in anti-money laundering or countering finance, terrorism controls, and/or domiciled in countries with weak export control laws or weak enforcement of export control laws, or where the transaction involves an individual or entity in a foreign country of proliferation concern, or where a pattern of wire transfer activity that shares unusual patterns or has no apparent purpose, or where there is missing or fraudulent documents within the transaction. Now, when we look at jurisdictional red flags, that would include countries with weak financial safeguards and which are actively engaged with a sanctioned country. So that may be like a country that where it's believed that individuals from that country are actively engaging with, say, North Korea, for example, or where there's a presence of an industry that produces dual-use goods, proliferation-sensitive items, or military goods. Now, some of these indicators would be equally applicable to even regular jurisdictions that have targeted financial sanctions in place. So while we're talking particularly about proliferation financing, but it may even be applicable when it comes to terrorist financing for some of them, i.e. you could be dealing with a country that knows that, or that tends to engage heavily with another country where there tends to be a lot of terrorist financing measures in place, or even sanction measures in place. And the country now that sort of falls to that category will be Russia. You know, it's heavy sanctions against Russia, which, although they're not UN-based sanctions, but there are a number of countries that have imposed very huge sanctions on Russia, and we'll come to that in a minute. Next slide, please. So we also thought it'd be relevant to say, how do we approach PF risks? So basically, we want to recognize that proliferation finance is a common problem with many major financial centers due to the unwitting involvement of various financial institutions worldwide. So your ongoing monitoring should not be limited to simply screening clients against the consolidated list, but should extend for identification of assets subject to applicable TFS, you know, where this is appropriate. Also, you want to conduct risk assessments of customers and products, country, geographic, and delivery channels, with special attention to trade, finance, and insurance. You also want to be alert to the possibility that your customers may be engaging in or facilitating proliferation activities. And you want to apply enhanced due diligence on high-risk transactions and entities. And you also want to develop situational awareness around various sanctions regimes. And this can be achieved by reading the UN Panel of Experts reports. Now you want to move on to Russia sanctions. So basically, the Russia Sanctions EU Exit Regulations 2019, as extended by the Russia Sanctions Overseas Territories Order 2020, imposed sanctions to encourage Russia to cease actions which destabilize Ukraine, including actions undermining or threatening the territorial integrity, sovereignty, and independence of Ukraine. The regulations impose asset freezes on those identified as being involved in destabilizing Ukraine or undermining or threatening the territorial integrity, sovereignty, and independence of Ukraine. In addition to financial sanctions, the Russia regime also covers trade, transport, and immigration sanctions, to name a few. So this includes, for example, there's an oil embargo in place with regards to Russia. So that would be considered a trade sanction. And this regime is very much evolving consistently since the sanctions were stepped up over a year ago, and we've seen numerous amendments to the regime and this is actually probably the most restrictive sanctions regime that has been seen in this day and age. Next slide. So basically, these increased restrictions came about as a result of the February 22 Russia invasion of Ukraine. And therefore, the Russia regime, like I said, was amended. And as a result of these amendments, the Russia regime is the strongest sanctions regime the UK has ever implemented. And the 22 amendments to the regime has allowed the UK to impose sanctions on Russia businesses and individuals in a wide range of sectors. And it's not just the UK that have issued these strong sanctions. We've also seen the US, Canada, Australia, to name a few, have also, Europe, the EU has also increased their sanctions against Russia. And prohibitions and designations have also been extended to government of Russia affiliated entities and businesses of economic and strategic significance to the Russian government, as well as their owners, directors, and trustees. We also know that it has been extended to Russian oligarchs. We see, just as a side note, we know that Abramovich, who used to be the former owner of Chelsea Football Club, was designated, and that resulted in the football club being sold and the like. And there are numerous other individuals that we can name that would have had similar sanctions imposed against that. So how has this impacted Bermuda? What it has meant is that more legal persons are caught in the net cast by the Russia sanctions regime. And since February 2022, the FSIU has seen a significant uptick in the submission of compliance reporting forms. We've received over 100, I think it's probably close to 150 reports now of suspected designated persons and frozen asset reports. The frozen assets reported to the FSIU since the invasion is in excess of 219 million. Designations have increased, which means that Bermuda registered entities must continue to be vigilant in their processes. if a client becomes designated or a designated person attempts to engage, entities must submit a CRF to the FSIU and should not engage in the prohibited conduct under the regulations.
Michelle?
Next slide. So with the increase in designated persons and entities, we've seen an increase in licensing under the Bermuda framework. So the Minister of Legal Affairs and Constitutional Reform has the power to issue a license authorizing otherwise prohibited activity under the various sanctions regimes. Grounds for obtaining a financial sanctions license in Bermuda include basic expenses of a designated person or dependent family members, reasonable professional fees and disbursement of incurred expenses in relation to legal services, fees or services charged for the maintenance of frozen funds or economic resources, routine maintenance of frozen accounts and economic resources, extraordinary expenses, and obligations under a contract entered into prior, or the obligations that arose prior to the designation of the DP in question. And basically, entities must determine whether their activities are captured by prohibitions under the regulations and if a license will be required to continue such activities. To date, we can say the minister, in addition to issuing several specific licenses to applicants, the minister has also issued trade licenses and general licenses under the Russia regime. So to date, 4 general licenses have been issued under the Russia regime, 1 general trade license, which had to do with dealing with Russian vessels, and 3 general financial sanctions licenses. 1 had to do with trust services, 1 was for legal fees, and 1 was in respect of the oil price cap. So in those circumstances, entities that were able to use those licenses did not have to apply to the FSIU or the minister for a license. They could rely on the general license and have to report to us that they are in fact using the general license while it was in force. Next slide. So we've pretty much come to the end. We just have wanted to issue the page with notes on the various resources. So we have a link to the International Sanctions Measures page, a link to the FSIU Financial Sanctions Guidance, a link to OFSI Notices Subscription Services, and also a link to the various financial sanctions targets by regime. And we can provide this resources page to Bermuda to disseminate for those that are interested in it. Next slide. Okay, now we're to questions. But before I touch on questions, I just wanted to also note that where an entity has already reported details of accounts or economic resources or other funds held for designated persons, you are not required to report those details again. For instance, if that CP was an amendment was received or an update to their details, if you receive another notice from us indicating that, so you wouldn't have to re-report, if you will. And it's also important to note that any failure to comply with financial sanctions legislation or to seek to circumvent the provisions of the legislation is a criminal offense and may result in prosecution. So I'm just gonna go to the chat to see if there are any questions. Are there any questions?
So if there are any questions, you can unmute yourself and proceed and ask your question, or you can utilize the chat function.
Hi, it's Duncan. And I was wondering if raising these compliance forms is different than raising a suspicious activity report with the FIA.
Yes, they are different because the compliance reporting form is going to be where you think you have a hit or where you are dealing with a client that is that you believe is a designated person, and you're reporting to us that you have frozen funds, or you're reporting that they were seeking to engage in some type of activity that they will be prohibited from due to the fact that they're designated. So that is, it's two different requirements, if you will. And just wanted to, I'm just looking at my notes, excuse me. So, like I said, because with sanctions, it's constantly evolving. People are constantly trying to, or bad actors are constantly trying to find ways and means to circumvent sanctions measures. And what we are seeing now with regard to case studies or what have you, or information identified through financial intelligence that highlights techniques that they are using to evade restrictions, particularly with regard to Russia. Some of the recent methods identified include for DPs, they will be transferring assets such as shareholdings and holding companies to trusted proxies, such as relatives or employees. Also, selling or transferring assets at a loss in order to realize their value before sanctions take effect. Another way is divesting investments to ensure ownership stakes are below the 50% threshold, or relinquishing previous controlling stakes. Another where alert suggests that it's likely that designated persons will explore alternative payment methods, including the use of crypto assets to move funds to circumvent sanctions. And this is often an attempt to mitigate reduced access to the SWIFT payment system. And this is a practice that has been observed by UK intelligence. So even, I don't know in this sector if you have noticed or you have clients that want to pay via crypto assets, or if you accept crypto assets payments, but that could be a method of payment that may put you on alert to just want to do extra due diligence to make sure that it's the client is reputable and what have you. And particularly also if you're dealing with clients from jurisdictions that raise an eyebrow for whatever reason, you may want to dig a little bit deeper, you know, try to look and see, are they connected to any designated persons or what have you. So that's the sort of thing that you would do that goes beyond just sort of checking against the consolidated list, if you will. Any other questions? I know for the real estate sector, this may not seem to be so relevant, if you will. However, and high value. However, you still have to ensure that you are complying with your obligations, number one. And although Bermuda does have a robust financial, or is a robust financial center, which has, really good safeguards in place, even when it comes to real estate, there are certain requirements, particularly for non-Bermudians when buying real estate or what have you. However, we also know that for the higher value properties, there is a market where foreigners can tap into that. So we just want to make sure that you're using your due diligence and the like when vetting such clients to ensure that the funds are reputable and the like. So although, like I said, it may not be something that you encounter in day-to-day clients, it's definitely something that you want to be aware of and that you want to be ensuring that you're complying with and just doing this extra, taking this extra steps where necessary. If you have questions, if you have a question after the fact, you can certainly reach out to Gladwina, or you can email the FSIU at fsiu@gov.com and send your questions in. And where we are able, we will provide guidance to you in respect of any issues that may arise. However, it's important to know that we do not provide legal advice. If it's something specific with a specific client, you may need to get professional, independent legal advice for that.
Okay, so if there's no more questions, thank you, Renee, and thank you, Jaleesa, for a very informative presentation. Now, before the dealer sector drops off, we just want to highlight that we'll be rolling out our Policing the Perimeter framework. So we will be reaching out to the dealers in high value goods sector to obtain information from you with respect to your transaction records. So you can.
Okay, excuse me, Gladwina, before I jump off, I just wanted, I'm sorry, neglected to say one thing. I just wanted to also mention that the FSIU is in the process, or will be in the process of rolling out specific outreach for targeted things that we have seen in sanctions. We know that one of them is going to be sanctions circumvention or the like. So when we're hoping to have at least commence that in Q4 of this year. So we will certainly share that information with Gladwina, and it will be an opportunity if you wish to sign up. It wouldn't be sector specific, so it'll be just general outreach. So if you are interested in that, we will provide the link to the superintendent of real estate that can share with the sector, and please feel free to take advantage of that outreach in the coming months. And if not, thank you so much for your attention and have a good holiday.
Thank you, Renee.
Okay, bye
So,
for now.
okay, bye-bye. So before anyone drops off, a reminder, just ensure that you put your name and company you represent in the chat. And as I was saying, for the dealers and high value goods sector, before you drop off, we will be rolling out our Policing the Perimeter framework. So we will be reaching out to each of you with respect to your transaction records, and you should receive a notification in that regard in due course. So we're going to move on to the last of the agenda, which is the relicensing reminders. And that's basically a brief overview of the industry notices that we had disseminated on June 16th, as well as our follow-up that was sent on June 27th. So by now, all of you should be aware of the fee increases, and these fee increases took effect the 1st of April. So for brokers, the license fee is now $705, and for agents, it is $120. Also, that came into effect the 1st of April was penalties, and that's for late submission of the financial annual audit report, as well as late submission of license renewals. So a license renewal is required statutorily to be submitted by September 20th. So it will be considered late if it is submitted between September 21st and September 30th. That $200 penalty will be imposed. With respect to the written real estate exam, you would have seen in a number of our industry notices dating back to last year that any real estate broker or agent license that lapse, you will be required to resit the exam. We understand that in practical terms, it does not seem reasonable. We did have the Attorney General's Chambers opine on that piece of legislation. And so part of our legislative amendments is to amend the legislation so that it's more practical. And we understand that there are many brokers who have operated for 20 plus years, And in those instances, we've had to have them retake the exam, unfortunately. So, this isn't a decision that we have made, it's a statutory decision. And I believe back in the previous legislation, 1976 legislation, it wasn't envisioned because we're seeing a contraction in the market whereby many brokers are seeking to relinquish their broker's license and trade with an agent. And I envisioned back in 1976 with that piece of legislation, it wasn't envisioned that brokers would want to downgrade. So unfortunately, any broker or any agent that decides to relinquish their license, they will have to retake the exam because it's considered a new application. With respect to the annual statistical return, we provided in our industry notice, should you have any proposed amendments to that form, that data code, that you can submit them by November 30th. As all brokers should be aware, the annual statistical return is due by March 15th, 2024. So once we receive any feedback, we'll make those revisions accordingly, take them under consideration, and the revised form would be issued and circulated by the end of the year so that you have ample time to make your submission. With respect to the AML independent audits, we've performed a desk-based review. Some of you have been notified, but all of you will have received a notification letter by next week, Friday, the 28th of July. So you would receive a notification letter with respect to when your next independent audit report would be due. With respect to the annual financial auditor report, now it's important to ensure that the auditor you do solicit to perform your audit is certified with CPA Bermuda and in good compliance. Now that's important because we have come across some scenarios where the auditor is not in compliance and the report will have to be resubmitted. With respect to the criminal background check report, so you would have seen an updated industry notice June 27th. So we did receive some feedback with respect to allowing and permitting reports from magistrates court to be accepted. And so for renewing applicants, magistrates court reports will be accepted. You have to go back at least 3 years. And so taking that under consideration, it did make logistical sense, being the last reports were due in 2021. And so the 3-year period would incorporate the 2021 report and the history of that research. So that would be accepted. And then for new applicants, Bermuda Police Service report is still required. So the magistrate's court report is only required for renewing applicants. And the report should be no older than 6 months from the date of submission of the application. With respect to passports, passports must be valid at the time of submission. If the passport has expired, then an alternative form of ID, ideally driver's license, and a copy of the birth certificate should be submitted. Both documents do not need to be certified. We know historically that there were issues having to pay to get these documents certified. So long as you provide a copy, that is sufficient. And the fit and proper person questionnaire is required for all applicants. And it is also required if there are material changes. So if you have a change in your compliance officer, reporting officer, their roles have changed, then a new fit and proper form should be submitted along with the required resume or CV. So that basically highlights the renewals, reminders. Are there any questions? We'll take any questions at this time. With respect to, yeah?
Edwina, it's Duncan. I think you
Hi,
might have
Duncan.
skipped over one of your pages that said something about the fee structure.
Oh, did I? My apologies. Let's see. So that would have been the first slide for the fee increases and the penalties.
No, okay, I thought there was another one. So therefore, my question is this. I was surprised to be charged $100 to submit my mandatory auditor report.
Right. Yeah. Yeah, I don't know what to say to that. It's a general filing fee. The $100 is a general filing fee. So across the Register of Companies, inclusive of the Office of the Superintendent of Real Estate, ideally, any filings that are submitted to our office incur a filing fee. So for years, historically, as we know, there has never really been a filing fee for this submission. And so that's why that has now been imposed. Are there any other questions on anything? So now with respect to outreach, because we understand that many of the real estate sector rely on the outreach facilitated by our office. So what we would do is reach out to you if you have any suggestions on any particular topics that you would like to see the Office of the Superintendent of Real Estate facilitate, then please communicate that to us so that we can include that, whether it be within this year or for our awareness strategy next year. And that could be with respect to AML, ATF compliance. Ideally, you don't see a regulator that facilitates granular, in-depth compliance training, but we try to assist where we can. So again, if you have any suggestions for any particular topics for training, then please communicate that to us. You can send it directly to myself, or you can send it to realestateLicense@gov.bn. And if you do have questions and you don't want to communicate them in this forum, then do please feel free to send me an email. My email is glomera@gov.bn, or you can send it to realestateLicense@gov.bn.
Katrina, this
Yeah.
is Lynette. So I don't have a question, but I do have a comment in
Yes.
regards to receiving the license, because I still to this date have not received my license for last year. So we'll be receiving our licenses shortly after.
Yes, you will. And again, we definitely apologize with the delays. We had a number of delays for various reasons. We were resource constrained last year. We do have an additional resource this year. So our aim is definitely to ensure that the licenses are executed and distributed in a timely manner. There are a few that still are awaiting their licenses, and those are being reviewed and will be issued. And they would be retroactively dated from the date that the broker or agent was compliant with all their filing requirements. So we do want to take this opportunity to thank you for your patience during that period. It was quite challenging for us, but we are now pretty much up to speed, and we just have a few offhand that still need to be distributed, and they will be distributed within the next week. So thank you, Lynette, for that reminder.
Excuse
Sally
me.
Ann, you have a question? Go ahead.
Yeah, I just want to make sure everybody is aware, because my company paid $100 for each of our police checks, and we've since found out that it's only $10. So I want to make sure everybody knows that, because obviously it was expensive to the company, and I think we all should be aware. And since we're all online here, it's a good time to let everybody know.
Yes, and that was
Edwina?
right. So basically, we sent out the industry notice, the initial industry notice on June 16th. Then we sent that out indicating that the Bermuda Police Service report was due. We received some feedback from various industry members, which we took under consideration. And that's when it was proposed, can the magistrate's court report be used? So we did take that into account. We understand that individuals may had already made their request through the Bermuda Police Service. And of course, those reports will be honored. Yes, we understand it's more costly, but those reports, of course, will be honored. And for the next reporting period for renewing applicants, magistrate's court reports will be accepted. So unfortunately, it's nothing that we can do with respect to any form of refund. If you did already make the request for Bermuda Police Service report, it's just with respect to the time and difference. But now moving forward, the magistrate's court report could be utilized for renewing applicants. And we do understand that there were a number of industry participants who already made their requests for the Bermuda Police Service report, which of course is the higher cost. So I hope that provides some clarity. And it's just with respect to the time and difference. So we took those industry feedback into consideration, and that's why the decision was made to also accept the magistrate's court report. Are there any other questions?
Yes, Gladwina,
Yeah,
I'm just not clear on this $100 filing fee. So in the past, when our finance audit report was available, we would just email it to realestate.gov. So now, what are we to do?
right. So with respect to the filing fee, so for all fees, the same way you pay your license fee. So we provided you with a spreadsheet that details what the payment is for. So actually, the spreadsheet is primarily for the license fee. So what you would do with respect to paying the filing fee is just send us an email saying with your payment verification, your wire transfer verification, that that's what the payment is for. An email would be sufficient. And you can send that to ROC accounts as well as to realestateLicense@gov.bn. And then our accounts team will process that payment.
And then once you have that confirmation, then you send your audit report in.
No, you would do that at the time you're making your submission.
Okay,
Yes.
that's new. Okay, thank you.
Okay.
I have a question.
Uh-huh.
On that Excel spreadsheet where we have the brokers and agents licenses,
Yes.
is there a way to insert filing fee on that same Excel spreadsheet?
We hadn't done so. So that's why we were saying an email would be sufficient. But I know many have already started the process, but we could add that fee in there to make it a lot easier and recirculate that to industry.
Okay, thank you.
Okay. Any other questions?
Hi, Gladwina, it's Lorene.
Hi, Lorraine.
Hi, everyone. I guess this was just a segue off of the other questions with regards to the filing fee.
Yes.
I was just going to say, is there a way to avoid that? I know everyone's mind is turning with that question, by just submitting it with everything else, because that's how it was done in the past. So, but you're saying it's not. And in order for the audit to be accepted and reviewed, it has to be accompanied by this filing fee. Is that the new policy?
I'm trying to understand your question. So you're saying if you can submit your audit report with all your other filings?
Yeah, like with the
Certainly.
licensing and all of that.
Yes.
Do we
Yes.
then avoid a filing fee because it's not separate? It's everything
No, the
submitted. one
filing
time.
fee is required. So whether you're submitting it independently or with your other filings, the filing fee of $100 would be an additional fee that should be remitted.
Okay, and that, what I'm saying is that's just started.
Effective the 1st of April, yes. So that was part of the fee increases, the Bermuda government fee increases, as well as new fees.
Okay, thank you.
You're welcome.
And we just want to reiterate to the brokers out there that you need to get these within 6 months of your year end. Otherwise, you'll be subject to a $200 penalty. So please keep that in mind, that financial audit report is important and that you cannot delay it, because you pay the $100 and if you get it in late, that's another $200. So keep that in your calendar and you'll be fine.
Yes, majority of the financial audit reports that we receive are late. So it's definitely important to make sure that you are submitted it on time to avoid that penalty fee. The other thing is with respect to completion of your application forms and application submissions. So we've set out to ensure you make your submissions when you have all of your supporting documents, because it creates an administrative burden if applications are submitted in piecemeal and incomplete. There's a whole form of back and forth. So submit them once you have your criminal reports from Magistrates Court or Bermuda Police Service and all other supporting documents, and then make your submission. Ensure that you title the subject of your submission for your brokerage and what the submission is for. Many times we receive submissions under our industry notice and it will get lost. So ensure that you title what the submission is and also your brokerage firm so that it can be adequately recorded and action accordingly. Are there any last minute questions? If not, we want to thank all of you for your attendance this morning. We are planning to do another outreach, and we will circulate that date as soon as we can. It will be a collaborative outreach with the Financial Intelligence Agency, and we're looking at around mid-August, mid to end of August, and that confirmed date will be circulated shortly. So we want to thank all of you for your time this morning. And if you have any questions whatsoever, again, you can email myself, galomera@gov.bm, or realestateLicense@gov.bm. Everyone have a blessed and safe day, and thank you for your time.
Thank you.
Thank you.
Thank you.
Thanks.
Thank you.
Bye-bye.
Bye-bye.
Bye.
Bye.
Thank you. Thank you.
Thank you. Bye.
Okay.
Thank you.
Thank you.